Today's topic is using your competitors' trademarks without breaking the law. Sometimes you need to use your competitors' trademarks to sell your products or services. For example, when you're selling replacement parts and need to say that they're compatible with the trademark owner's products. It can also be important, for example, when you're providing repair services. If you repair BMW cars, you need to let others know that. Fortunately, if you do it properly, you can use other companies' trademarks and avoid trademark infringement. Trademarks protect the reputation of a business. They also identify the source of goods for consumers. The test to determine if there's trademark infringement is whether there is a reasonable likelihood that consumers will be confused as to the source of the goods or services. This is also the underlying test for fair use of trademarks and the test as to whether a use is fair. Will consumers be confused as to the source? If you make it clear that the source of your goods and services is different from that of the trademark owner, you should be good. But remember, fair use is a defense to trademark infringement. No matter how fair your use of a trademark is, there's always the risk in using another's trademarks. The owner may be motivated to sue to prevent that use. If you decide to use another's trademark, before you do, consult trademark counsel. Get an opinion as to the strength of your fair use defense and the risks that you might be facing. This video is not legal advice. It's just for educational purposes. I'm going to talk about two common types of fair use, descriptive and nominative. Descriptive fair use occurs when you're using the common meaning of words to describe your product, but they happen to be the competitor's trademark. Normally, these types of trademarks are weak because they're descriptive. My next video will go into detail about the strength of trademarks and how to choose strong ones to avoid this problem. So stay tuned to this channel. In fact, if you would, please like and subscribe. I do these videos regularly, and I'd really appreciate knowing that you like them. So, like I was saying, descriptive fair use normally applies when the trademark is descriptive of the goods or services or their quality or benefit. Using terms to describe your product is fair use if you use them in good faith as descriptive words as opposed to trademarks, and it's necessary to adequately describe your product. An example of this is the trademark Sweet Tarts. Sunmark owned the trademark Sweet Tarts for candy. Ocean Spray used Sweet Tarts to describe their cranberry juice. One of their ads stated, "Ocean Spray cranberry juice adds vibrant color, texture, and unique sweet tart flavor to any dish, with the healthy goodness of fruit." Sunmark sued Ocean Spray for that advertisement, and they sued them for trademark infringement. The court held that Ocean Spray was using Sweet Tart to describe the taste of their juice and not as a trademark. They also did it in good faith. Therefore, there was no infringement of the Sweet Tarts trademark. The other fair use is nominative fair use. Nominative fair use is when you identify a trademark owner by its trademarks. It typically occurs when you compare your product or offer replacement parts or repair services, for example. The general test used by the courts in determining whether the use was fair is 1, whether the product or service of the trademark owner is one that is readily identifiable without the use of the trademark. 2, whether the mark has been used more than is reasonably necessary to identify the trademark owner. And 3, has the user falsely suggested sponsorship or endorsement by the trademark owner. The classic case of nominative use is comparative advertising, such as Coca-Cola tastes better than Pepsi, or vice versa. You have to use the marks to identify the products. This use is normally reasonable. There's no over-mentioning of the other trademark, and there's clearly no sponsorship or endorsement suggested. Consumers just aren't going to be confused. Another example is for repair services for automobiles. Volkswagen sued Donald Church for using their trademark Volkswagen and VW in advertisements for his repair services. His advertisements always used independent whenever the terms Volkswagen or VW were used. The court held that his advertising was sufficient to distinguish his business in the eye of the consumer. There wasn't any false suggestion of sponsorship or endorsement by the trademark owner. The court felt that consumers would understand that independent means no sponsorship or endorsement. An example of fair use concerning replacement parts is the Keurig compatible coffee machine pods. To sell replacement pods, coffee makers have to indicate that the pods can be used in Keurig machines, or at least they want to. But it's important to not suggest sponsorship or endorsement by Keurig. Keurig sued Strum Foods for using the Keurig trademark on their Grove Square coffee. The Grove Square packaging stated for use by owners of Keurig coffee makers, and it stated that Strum Foods had no affiliation with Keurig Incorporated. The court focused on these statements as supporting nominative fair use and dismissing Keurig's motion for summary judgment. The court also suggested that using language such as compatible with Keurig coffee makers was likely a better alternative. The key is to let the consuming public know that you're not endorsed or sponsored by the trademark owner. One of the best ways to do this is to use a disclaimer statement that clearly spells out that you have no association with the trademark owner. Also, using your own trademark on your products and words like compatible with will help. Using your competitors' trademarks is not for the faint of heart. Your competitors will likely take notice, and don't be surprised if you get a letter demanding that you stop. Unfortunately, there's no bright line test for what fair use of another's trademark is. You have to take great care, and you need to seek advice of legal counsel. That is very important in this rather murky area of the law. If you're unsure, give me a call and we can discuss. Call me at 248-433-7381. I've provided links below. One is to my book, Invisible Assets, How to Maximize the Hidden Value in Your Business. This book will help you understand your business's IP and its value. It will explain the traps and mistakes in the complicated world of IP. It's a quick read, and it's written just for business owners. It's not written for lawyers, so it's pretty understandable. At least I hope that's the case. That's what I've been told. I've also provided links to my intellectual property guide and checklist. This is a great resource for better understanding what IP you have in your business and for avoiding IP litigation. So click on the links below for your complimentary copies. Thank you for watching. I truly appreciate it, and I look forward to seeing you in the near future. Have a great day.